Arch. Color guard. Hold. Ready. Face. Present. Colors. Carry. Colors. Ready. Cut. Ready. Step. Ready. Face. Forward. Arch.
Please be seated. I want to thank the Honor Guard for the presentation of colors. The court appreciates all of the effort that is undertaken to make this community program work. There are a number of entities that are involved in this process. A number of local community businesses have contributed to underwrite the cost of this. And the local bar association members have contributed their time to work with the students and the local courts. They're all required to make something as complicated as this come off the way it has. This is our 19th such program. As I said, dependent on all the local participants, and River Rouge has done quite a wonderful job in making this thing come true. We have today with us the following schools: Allen Park, Cabrini, Cesar Chavez, Ecorse, Flat Rock, Gabriel Richard, Gibraltar, Carlson, Grosse Ile, Lincoln Park, River Rouge, Riverview, Southgate, Anderson, Taylor, Kennedy, Trenton, Wyandotte, Roosevelt, and Woodhaven. We welcome all of you here today. And everyone watching the live stream, including the community members viewing these proceedings online. I want to do a couple of housekeeping items. With the exception of the media and professional photographers, no one is permitted to take pictures once the oral arguments begin. There will be plenty of opportunities for photos during the reception. Also, if you have not already done so, put your cell phones on stun, cut them off during the remainder of the proceedings. Following oral argument, please remain in the courtroom for debriefing with the counsel for the parties and Tom Clement, our Supreme Court General Counsel, who will mediate that discussion. This is Tom's first appearance as the mediator, so I urge you to keep him on his toes with extra tough questions. There are not many depictions of appellate courts in movies or television, probably because there isn't a lot of drama associated with them. But we do a different job than the trial courts, where there's a lot more action. The trial courts decide what the facts are and they make a record. The appellate courts don't make a new record. Instead, we work with that record, and we are asked by the parties who found fault with the result in the lower courts to review that record and determine whether there is a legal error that has been committed and whether that error warrants a different outcome. And that's why we're here today. One of the parties believes that the lower courts have made a legal error that should change the result. And oral arguments are a key part of the appellate decision-making process because it helps us determine the outcome for the parties in the case, and which may affect the future outcome of all the cases of like kind that follow. So by the time of oral argument, the justices have become very familiar with the case. We have read the parties' briefs and the lower court record, and have studied the legal issues. The questions we asked during oral argument and the counsel's answers do help us to reach a decision, but more important, they can help us to focus on the issues that may eventuate an opinion, so that we can craft an accurate and clear statement of the law. So, like us, you have already studied this case. You know what the issues are. You come to today's oral arguments with questions you would ask if you were a justice. And when the court issues its decision, you will get to analyze our ruling and decide whether you agree or have done things differently. So our goal is to leave you better informed about the rule of law and its role in our constitutional republic. My hope is that as a citizen of our community and state, you will actually remember this experience. Our form of government, which requires its citizens to be self-governing, can only survive if its citizens remain informed and involved. And with that, I'll call the case Ray versus Swager.
May it please the court, Ben Johnson and Chris Desmond as plaintiff appellants. I come before you today, and I want to thank the court for, again, being in such an important case in a school setting, yet again being in front of a school. I come to you not just as a lawyer, but on behalf of a son of a high school teacher and principal. This case presents this court with the opportunity to, in my opinion, expand exactly what you folks, this court, decided in Beals, but especially to define governmental immunity on the proximate cause as to whether it can ever be found to be the proximate cause in a situation where the actual government actor was not him or herself engaged in the actual injury. Beals, as this court knows, was an entirely different factual scenario. And one of the things, Justice Zara, that you in the majority opinion talked about was Beals voluntarily entered the pool, voluntarily got in the shallow end. I'm on page 10 of the opinion. Voluntarily dove under the surface of the shallow end of the water and swam into the deep end without emerging. That issue in that case, as the court already knows, was the alleged supervision of the lifeguard. Here, in fact, also on page 10, you continued that Beals, the lifeguard, did not cause Beals to enter the pool, to swim in the deep end, or to act, if you will, with the accomplished swimmer perform voluntarily, that is, go under the water and again enter the deep end on his own. But what we have here is an entirely different situation. We have here where, analogously, it'd be the lifeguard telling my client, ordering him, get in that pool, knowing full well that there was some kind of a law against it. We have a red light, a 13-year-old boy on the first day of school tryouts with 22 other students who get to the red light with a stop sign, if you will, for the pedestrians. They stopped. I think it's very important factually. The team stopped, and they were all supposed to be together. They stopped. One of the students pushed the button, which I think was Mr. Henschel, and then coach told him, go, or run. In fact, Mr. Bowersox at Exhibit G of our brief, 22 to 23, yelled, he heard coach say, go faster. So not only did the coach instruct these children to violate the law knowingly, but he did so after knowing that the car was already on the way toward the intersection. He did so then leaving the, quote, slower students behind. not waiting for all of them to cross, and did so knowing full well that the car continued to go again towards his students.
Are we allowed to interrupt him now?
No.
We're going to interrupt you now.
Yes, Justice.
That's what we do. So let's just assume, so we can move to like sorting out what the doctrinal question is here, that the coach's action was grossly negligent. That's not something we have to decide today. We're just trying to figure out what the proximate cause means in a situation like
Correct.
this. So let's just assume that for a second.
Yes, Justice.
And assume also, just for the sake of my question, that his direction makes him a proximate cause. He put something into motion here. But how do we figure out, as between what he did and what your client, the plaintiff, did himself? He did run into the street without looking both ways, I assume, or he wouldn't have run into the road. How do we choose between those two proximate causes? Which is the proximate cause?
The answer
Or
is
the one most direct or efficient cause?
the answer is you don't. The jury does. And as this court knows, this was on a summary disposition motion pre-trial, where we're proceeding on depositions and so forth. All the evidence is not before the court. And when you,
So let me suggest it to you that I want to hear your next best answer, because if everything's a jury question, that's going to scare. I mean, the reason we're like, the government immunity statute is supposed to give courts some way to decide which cases that the government actor should have to defend himself before a jury. And it's a high bar. It's not a wall, right? The legislature could have said no government actor ever has to pay, but it's a high bar. So the court has to be able to enforce that bar. It can't be that every question is a jury question when there's more than one proximate cause. So how does a court, how would a court, if it were interested, fashion a test that could help us sort out, so trial courts and appellate courts could separate the wheat from the chaff, how to think about which is the most direct, efficient, immediate of the causes?
well, historically, proximate cause is an issue for the trier of fact. I should have asked for.
Historically, just
I
a
know,
moment.
but this is a statute, and we have statute, and we have a 16-year-old precedent interpreting that statute. So I'm just trying to work within what the law is, because that's, you can go to another branch of government and remind them what proximate cause meant historically, and you might win. But in this branch of government, we have a statute, and we have the way the court interpreted it. So
I
I'm
agree,
asking
Judge.
you to help me with how this court could fashion a test when there might be more than one proximate cause.
Let me just, to frame the issue, this is how the court in Robinson, which represented a departure from prior cases, it defined the proximate cause as used in this section of the Act to mean the one most immediate, immediate, efficient, and direct cause preceding an injury, not a proximate cause.
Yes, Justice.
I mean, that's the problem. You want to transform a circumstance in which there are more than one proximate cause into a jury question, and I think the statute requires at least the courts to determine whether there is the proximate cause. And so, recurring back to Justice McCormick's question, what is the calculus to determine, as between these two causes, the coach's statement that they should run against the light, the child's failure to observe the statute you cite in your own brief that requires them to honor the traffic light and to look both ways. As between those two, those both seem to be proximate causes.
Agree.
The question is, does the jury get to determine the legal question? I don't think they do. So
Well-
what is the calculus for a court determining which, as between those, one is the proximate cause?
I neglected to ask for 3 minutes for my rebuttal, so I'm doing that now, if you could, please. Thank you.
Ask
Thank you.
whether you get to use it.
I
is
hear
another
you.
question.
Yes, Justice. Yes, you Justice. When there's a genuine issue, Chief Justice, on whether which one is the most efficient, that should be a jury submissible issue. There is not going to be, in fact, just in the Beals decision on page 14 at footnote 31, 30 and 31, this identical situation, in my opinion, was carved out, and this
And
court,
we declined to answer the question.
but it was raised, and when you talked about how if this governmental actor in that particular case did not take affirmative action to increase the danger posed to the individual, that's what Swagger did.
All that footnote says is that it's an easier question. It's an easier question to answer when there's no affirmative action. Justice McCormick's question to you is, how are courts to determine when there is such affirmative action, that becomes a question of fact for a jury? And just don't tell us all of them are jury questions, because she hinted to you, even told you, that's not going to sell. We
I
need to have
didn't say
something
that they
more
all
for the
were,
statute in
Justice
place.
Sarah. But in this case, it is and it was.
Why? And how do
Because-
we apply that in future
Because,
cases?
because when you have a governmental actor ordering, that's what this is, ordering a child to do something they wouldn't do, just like the Court of Appeals, and I understand they were unpublished
But
decisions.
wait a minute, there is the independent legal obligation, frankly. I understand this is a 13-year-old child, and it's a horrible outcome here. But the child did have the obligation to look and to honor the traffic signal that told him not to cross the street. They're both contributing to the horrible injuries that occurred here. I don't know why you believe that that a jury gets to determine what the most proximate cause is when that is a legal determination. And let me simply say, I'm having difficulty because we very specifically said in Robinson that the proximate cause is not a proximate cause. So I'm still inviting you to tell me how you make the calculus.
I'm trying to, I apologize.
We
Number-
sometimes like to talk about, go ahead. And then I have
Number
more.
one, I would obviously invite this court to revisit Robinson, which I believe was wrongly decided, but you knew that I was going to say that.
Okay.
Moving on, thank you.
Noted.
In both the White and Hurley cases that we've cited in our brief, where there was a governmental actor instructing children to do something that they knew was wrong and unsafe, the Court of Appeals in both of those situations declined to do the very thing.
Are those
that-
presidential cases?
They're unpublished decisions, Chief Justice, but what's interesting is they're only cases where we've been able to find anywhere in Michigan where a governmental actor, teacher, expressly instructed a child to do something that the child either A, didn't want to do, or told the teacher was unsafe, and it happened anyway. And in both of those cases, the Court of Appeals declined to do exactly that and found that a reasonable jury could determine that the defendant's conduct alone was the proximate cause.
The unpublished case of Gray versus Cry had a teacher telling two students to fight, and the court said there wasn't a question of proximate cause there. So the unpublished decisions really don't help us.
Counsel, can I try and propose some possibilities?
Thank you, Judge.
And maybe you'd like one of them or not, I don't know. I mean, you could have imagined, so let me take a step back. The language, the one most direct, deficient, immediate, I forget the order, is in a way it's a list of synonyms for proximate, so it doesn't give me the answer to the question I keep trying to ask you, which is, what would a useful test be for courts trying to sort out as between more than one proximate cause? And Robinson, there was more than one proximate cause. The case it cited to come up with that language, a very old case, there was more than one proximate cause. So it wasn't the case that the Robinson court, from what I can tell, was saying the only case where a plaintiff survives is when there is only one proximate cause. It was deciding as between more than one, which one is the proximate cause. So, one way might be, you could say, like in comparative negligence, if the government actor is 51% or more, it goes to a jury. That's probably going to scare courts and might not be consistent with a statute that wanted a high bar. Another way might be if there is more than one, if there is an intervening independent cause, the government actor is immune, right? An intervening independent cause. So let's work with that for a second. You would, if that were the test, have to convince me that your client's own negligence, just assume that for the sake of this argument, was independent of the coach's negligence, or not. You'd have to convince me that whatever he did was not independent of the coach's own negligence. How would you convince me of that?
Well, in this particular case, since you have a 13-year-old child who is on a team who's being ordered to cross the road,
Okay,
just
so now I
like
think you're onto
21 other
something.
students did.
Now I
Just
think you're
like
onto
the
something. So-
cars, the police officers in Robinson initiated a chase that led to the injuries.
Can I just finish with my hypo? Just let me just keep them on one track. We're on the same track. I know we're not letting you talk at all, but that's.
That
that's
may
all right.
be
We
a good
talked-
thing.
yeah. I mean, here's why I think this is a hard case. If this were a college senior who the record showed regularly disagreed with his coach, even stood up to his coach, I don't think you would have filed this case, right? I don't think you would have. If this were a first grade cross-country running program and, the facts were all the same, I think you would have already settled this case, right? But instead, we have a 13-year-old who is right on the verge of I hope my 13-year-olds know to look both ways, and I hope they will even stand up to their coaches and teachers when they ask them to do things that are unsafe. But I realize that 13 is not 23, right? And it's not 6. So you're right in this this hard area if we think that we have to figure out whether your client's own actions are independent of the coaches.
When you have a personal authority like a coach instructing it to do something, to me, that's clearly going to be something different than any other scenario, Justice McCormick, that you're talking about. My client was there because of one reason, and he was ordered to do so. And 21 other people, seniors in high school all the way down to freshmen, just like my client, hadn't even gone to school yet, did the same thing because they were ordered to do so, as the
How is that
record shows.
different in kind from all of our published decisions where we are interpreting fact patterns that have a precipitating action that is followed by a series of other causative activities, and we say that the precipitating action is not the proximate cause? I don't see, now, if for example, at the stoplight, the coach had, in some joking and negligent manner, hip checked the kid into the street and into the oncoming car, I think you'd have an easy case of the coach's action being the proximate cause. But I'm having difficulty understanding when the auto that struck this child sped up to get through a yellow light and the child himself didn't look where he was going in the way that you're supposed to at an intersection. I don't understand how you can determine, and by what calculus you determine, that only the coach's actions were the proximate cause.
And again, Chief Justice, my position is because of the authority of the coach, and it's not an equal situation in any other situation you can imagine, but in a school setting where you're ordered to do something.
So this is a school child exception to the proximate cause?
It certainly looks like there's one emerging under Michigan law, albeit so far in two unpublished
Emerging
cases.
where?
Sure. Table saw, where a teacher instructs students to table saw
It's an unpublished case.
and tells you not to. Well, the fact that it's not published, I understand it, but the fact pattern does exist, and the analysis exists. And therefore, when you
But
have...
it isn't necessarily, it is not precedential. All the precedential cases do not favor the proposition you are advancing.
Other than Beals, which left a situation just like this in footnote 39 when it said, under what circumstances a chain of events might constitute the proximate cause of an injury or death in a different factual scenario, that's what this case is.
And that's why we're asking you to help us understand what the calculus is.
Mr. Johnson,
I'm trying to.
Mr. Johnson, I have a question before you're done, because I think you are
You are
out of time.
done.
But the,
Sorry.
I'm going to try to get a word in edgewise. And here's my question. Are you conceding in this case that there are two proximate causes? Because when I listen to your argument, the focus of your remarks today, it sounds more to me like you're saying that whether the student was negligent is an issue of fact because of all of the facts related to the coach. That the coach directed the students across the street against the traffic signal, knowing a car was coming in the dark on the first day of practice, all of those facts combined. So I don't want to make your argument for you, but that sounds like the position you're taking? Or are you conceding that there are two proximate causes, and then we're right to the question that Justice McCormick posed, which is how in the world should we try to do a comparative proximate cause analysis of the kind that really courts nowhere else have ever done, and so we're trying to figure out how to do. So before we get to that question, are you conceding there's two proximate causes here?
As it relates to the trial court setting, Justice, the defendants in this case are arguing multiple causes, proximate causes. That's what their argument is. In this particular case, though, the most, if you will, the most immediate cause was when the coach ordered my client to enter the intersection on a red light, not even the red light, but knowing the car was coming toward him. To me, that is it'd be different if he didn't know the car was there and saw nothing.
Are you conceding that your client was negligent?
I am not conceding my client. I know that they're going to argue that. But here, the question that the court put before us is whether, under this particular situation, whether a reasonable jury could determine that. And a reasonable jury absolutely could determine that Swagger's conduct was the proximate cause and still be reasonable.
Mr. Johnson,
Yes, Justice Martin.
if this court attempts to ascertain the apportionment of fault in this case, concluding hypothetically, and for example, that the defendant was 40% at fault, the plaintiff was 30% at fault, and the driver was 30% at fault. If we engage in that kind of analysis, are we doing anything that's at all relevant to the proximate cause determination required of us in this dispute?
My argument, Justice Markovich, you shouldn't do that. That's why we have trial courts, when we have reasonable minds that could differ, genuine issues, material fact. And unfortunately, what I see is a trend maybe going that way, and where someone's trying to determine whether there is only one cause versus others. And again, under the Beals analysis, but specifically, as Justice Zara talked about it, leaving it open, an open issue, that issue does remain open, and we believe that where you have a state actor that orders someone to enter the roadway, knowing full well that there is danger there, not just potential danger, seeing the danger and ignoring it. We believe it's the most immediate.
When you use the word orders, by the way,
Sure.
it strikes me that in the two unpublished cases that you cited, there was more clearly an instance of the principal or the teacher in those cases, in fact, ordering that something be done, something of an unusual nature, not ordering somebody to cross the street when a car might be coming, which would seem to be something that any person could have a pretty good sense of. But in those two cases, the teachers were ordering something more technical be done by a child who really didn't know his way around those technical adventures. But again, I want to ask you, it is not relevant, I'm understanding you to say it is not particularly relevant for this court to be seeking to apportion fault. That doesn't really move the ball forward in terms of determining whether or not the proximate cause standard was or was not satisfied. Is that right?
Well, when you say having the court do it, as opposed to if the court were to enter any kind of an order doing it, of course, no, that's not what I believe this court should be doing. That's a trial court. But at the same time, for arguing about the most immediate proximate cause, if we look at an analysis and see that there are two or more that are potential, that a jury could be reasonable.
Well, there's three or more that are potential here, are
You
there not?
could argue that, and that's exactly what they have argued. And I would argue that if a jury found something different, that the coach was not the most immediate, because that's going to be a question on the jury question form that I know this court knows, a verdict form. That's exactly the question they'd be answering. And if they answered the coach, I would argue obviously that it's reasonable. If the jury said not the coach and it was something different, depending on what it was, yes, it's arguable that that would be reasonable. But here where you have other possibilities, and that's where, again.
Thank you.
Thank you, Chief Justice.
Excuse me, I failed to do so at the beginning. Our news colleague, Joan Larson, isn't here because she's ill, and frankly, I had to persuade her not to come. She is actually watching online, and we wish her well. She would be here but for my persuasion, so I'm sorry to interrupt you, but you may continue. Thank you.
Good afternoon. Timothy Mullins appearing on behalf of Coach Schweiker. This case you've asked us to address in particular, the proximate cause aspect as it would apply to the liability of an individual government employee. Liability can only attach if first there's gross negligence, and also, even if there's gross negligence, as the cases, as you've referenced, must conclude that that gross negligence itself is the one most immediate proximate cause of the injury. I would argue that the facts in this case, as posed by the plaintiff, would indicate that the Court of Appeals had it right, and you couldn't change that situation without reversing the holding that you had in Robinson, in Dean, in Ream, in Lemieux, and in Beals. We've been asked to address, could this situation create the proximate cause? In each one of those cases, as you've pointed out, Justice Young, it's a situation where the governmental employee or officer was involved in a situation that created, if you will, danger and resulted in injury to someone. The holding in that case and each of the other cases is that, however, there's no liability unless the injury is immediately caused by the gross negligence. The difference here is the fact that Mr. Johnson said in his first sentence, when the students and the coach approached the intersection, they stopped, they pushed a button, they looked, they saw a car at the distance and determined that it was safe to cross the street. And they did safely cross the street. The accident occurs later. It is now a different time. The car is closer. The student who is farther behind has come up. And he, as has been pointed out, still has an obligation to look to his own safety. And what does he do? And I pointed out in my brief at length, we've got 20 different students here, as a cross-country team is. They're stretched out. And there's no dispute of fact whatsoever that the coach and the students could see the car. And the driver himself has testified that he saw the students crossing the street ahead of him in the crosswalk. And the immediate proximate cause of this injury is that neither the driver nor the student, who could see each other, avoided the accident. And all the student has to do, and I don't mean to trivialize, but all the student needs to do is to bear that responsibility that he has for his own due care to do what he's told at the earliest of age.
So
So wait a minute.
Go ahead, ask the question.
Well, I don't, so when the court in Robinson said that the proximate cause is the one most efficient, direct, immediate cause.
Yes.
Do you believe it wrote out that the cause had to be foreseeable? I mean, the driver, it is not foreseeable that when you're driving in the dark and you have the light, that there's going to be somebody running in front of your car. So put the driver out of the equation. You don't believe that Robinson meant to redefine proximate cause as proximate cause and but-for cause, right? Do you believe that?
Well, the statement in Robinson is that when you look to what the legally effective, if you will, or actionable proximate cause would be, it must be that immediate proximate cause that physically caused the injury. That's the actual
statement. So then your
statement.
answer to me is yes, you believe that Robinson redefined proximate cause to include but-for or cause and fact. You think it's any cause and fact, proximate cause.
Well,
In a case like this, you have a government actor who is a proximate cause. You may have a kid who's a proximate cause, and I want to talk about that. And the car is what actually hits the kid. That is a but-for cause. That is a cause and fact. That is not a proximate cause. It's not a legally responsible cause. You don't believe Robinson wrote out foreseeability and legal responsibility from the definition of proximate, do you?
Well, I mean, I do believe that the car is a proximate cause. I mean, the driver was a defendant. It is the driver in the driver's car who struck the student.
The driver was a defendant, right?
He was a defendant, yes.
Not anymore.
No, but I mean.
Because the driver's not legally
the case-
responsible. The driver is a but-for cause, not a proximate cause. So
Wasn't there proof in the record that the light turned yellow and there were students who testified that they heard the car speed up to get through the light?
The driver himself said that he had done that. He knew that, he said, it's right in the police report, that this is a quick yellow light. He even said this light makes him nervous. He had been driving at it, and he knew that he was on his way to work. It's time for him to get to work. It's already 7 o'clock. He's supposed to be at work at 7. I mean, you can see what's happening here. He's hurrying to get through the intersection, and students testified that he accelerated into the intersection when he also said that he saw a group of runners in the crosswalk crossing the street.
Okay, then
And it's his car that struck the student. That's the injury. That's the proximate cause of the injury, the
okay,
car.
I feel like I got way distracted. In fact, add the driver. I don't care how many approximate causes there are. I understood the record slightly differently, but I want to ask the different question. I want to ask whether the one most direct, efficient, immediate cause also includes but-for causes, includes causes in fact. Do you believe it includes every potential cause, whether it's a proximate cause or not?
I guess it sounds like you and I are defining proximate cause differently. I understand proximate cause as being a factor that,
I can
proximate
only define
cause
it
is
the
that
way-
which can contribute to the injury, and that all of these different things, whether it might be whether the light is red, or how fast the driver is driving, or whether the student looks
Okay,
or
well-
not, those are all proximate causes.
Well, you tell
from
me
That's
how-
what Paul's graphs teach us
Let's go
when
with
we're in
that.
law school.
Yeah,
But in Robinson, it's unusual, and if you will, contrary to the Paul's graph type of thinking, that we only look at the one,
no, we
the
look at
last,
we look
the
at
most immediate physical
We
proximate
look
cause.
at the one most immediate, efficient, and direct proximate cause. So that assumes there might be more than one, right, if it's the one most. And in Robinson, as you know, there was more than one. And in the case it quoted from, Stoll, the sleigh case, I'm sure you're familiar with
Correct.
it, there's more than one, right?
Yes.
And in both of those cases, in fact, it wasn't the most recent, so it can't quite be just most recent. In both of those cases, it was the plaintiff's action herself on her sleigh, or the plaintiff's action in driving in a unsafe way that came before the next proximate cause. So it's not as simple as most recent. So how do we choose, if we were to try, maybe it's impossible, but if we wanted to try to give lower courts direction on how to choose between more than one proximate cause, and maybe it's 2, maybe it's 3, maybe it's 8, how could we fashion a test that would be helpful?
Well, I mean, examining the legal effect, or what is the one most immediate proximate cause, requires looking at the facts as they're presented, and they'll be different in different cases. But as the cases are written, it's indisputable in my mind that after the coach has done whatever he's done, he's now gone. He's across the street. He's down the road.
Your answer, you're telling me how we would apply a test in this case without telling me what the test is. I'm suggesting to you that I find the list of direct, efficient, and immediate to be a great list of synonyms for proximate, but not a helpful way to think about the question that courts are going to face a lot, which is when there's more than one, how do we figure out which of those is the most immediate or efficient?
As to which one is the last one physically causes the injury. In this case,
Well,
the student could see the car
The
and
last
could
one would have
see.
meant Robinson would come out the other way, so it can't be that simple. It can't be last. It's got to be a little bit more than that.
Is there an intervening
There we go.
fact
I like that.
that occurs after what the coach is criticized for?
Would that intervening fact tend to represent some kind of meaningful human agency?
Yes, absolutely, in this case, and that's exactly it. Here you have a student of mature age who rides motorbikes. Testimony's undisputed. He rides on busy roads. He's used to being in traffic. There's no reason, unlike a special education student in a pool, who you might have a much higher duty of care for. But here, you've got no reason to believe that this student, he participates in marathons and bike rides, and that's all very clear, that he comes to the curb and crosses into the light behind people when the car is right there
But if
to
we're
be
looking
seen.
to meaningful human agency as a potentially intervening factor that would affect the proximate cause on the part of the defendant, it has to be meaningful. And the question is whether or not that agency is meaningful here when arguably his conduct was taken in direct and necessary response to what the coach told him to do. That's not a meaningful human agency, is it? When you act in what you feel is a responsive manner to what somebody who's supervising you orders you to do?
Well, when you say meaningful, there isn't anything in the record because he has no memory whatsoever. We can't say why. We don't even know if he heard the statement. But to be meaningful, my argument would be there's nothing that relieves him, as Justice Young indicated, of the responsibility to look to his own care. And so it's meaningful for him to step off the curb against the red traffic light when the car is right there. That is a meaningful action on his part that is the direct reason he was injured. And again, not to trivialize.
Counsel?
Yes.
I want to give you a hypothetical. First off, good morning, and to both counsels, thank you guys for being here. But I want to give a hypothetical because I didn't really get an answer. I don't think we got a real answer to Justice McCormick's initial question. So I want to lay out a hypothetical for you, and I want you to kind of follow me through this hypothetical and see kind of where we get. For people who are blind, the state has, through the Intermediate School District, programs to teach you life skills. It's a critical component of being blind. These are state educators who come and teach you how to do certain things in life, right? One of the key things that you spend many years learning as a blind person is how to get across the street. So follow me through this hypothetical. Let's say you have a blind student who is under the care of the state, who's going through the ISD. They have an orientation mobility instructor that is with them. That orientation mobility instructor is teaching them how to navigate a very busy road, which is customary. Let's say we use Telegraph Road. They're teaching them how to cross the road. Now, very quick, you have a situation where the blind person cannot appreciate the danger, right? They can't appreciate it. They haven't learned how to cross the street yet, so they haven't appreciated the danger. They're now at Telegraph Road. They don't have any ability to know what's coming or going, and they are following the instruction of the orientation mobility instructor who is instructing them as to how to do it. For whatever reason, we're not talking about gross negligence, the instructor has a glare, they misread the sign, and they feel that the sign says walk when it really says don't walk. The blind person is instructed by the state educator to immediately start crossing the street. The light is not a walk, it's a don't walk. A truck who does not do anything wrong, who is following all the traffic rules, collides with the blind student on Telegraph Road and kills them. Is the teacher in that situation the immediate, efficient, direct cause of that student's death?
I suppose that argument could be made, but I don't think that hypothetical applies to this situation because...
No, Counsel, I'll tell you what, in a nice way, I'm going to tell you what applies and what doesn't. This is a hypothetical that I have asked you because we're looking for a standard and we're trying to understand and appreciate the standard. What I've asked you is a question. In that situation that I have given you, is the teacher the immediate, efficient, direct cause of that person's death? I'd like an answer as to the standard that we're trying to look at.
Well, I would have to know all the facts as to whether
I've given you all the facts.
Well, under that facts...
Pretty straightforward hypothetical. I would just like an answer.
If there are no other proximate causes,
Okay.
which is the way you're putting it, that would be as if this student himself were blind. But the fact is that he wasn't blind, and that's the difference.
Counsel, you're not answering my question. I've asked you a question. It's a relatively straightforward question. In the hypothetical that I have given you, what is the answer?
in that case, that would be akin to, as Justice Young pointed out, the coach nudging him out into traffic. If he's
So in
actually
that case-
physically, if his audible command.
Counsel, in the
It
case
sounds
that
like
I've
yes.
given you,
You
the
got
answer
it.
is yes, correct?
Again, I would have to analyze it more than I have, but that's with him directly being involved and there being no other basis for the person stepping out into telegraph.
The
You
answer
can
is
give
yes.
Justice Bernstein a yes, and still different your
Yeah.
case. It's not really, it won't
I thought I
hurt you
did.
to
If you
say yes
disagree
to
with
a
premises, you
hypothetical.
can say, I disagree, but what you've given me, yeah.
Yeah.
He's the only cause.
Yeah, it's-
If he's,
I'm
if
gonna
he's
settle
the,
with
if he's
Justice
the, if
Bernstein.
he's
I'm
the
gonna settle that
only,
case.
there's nothing else that you can distinguish, and he's the only one most immediate proximate cause as to why the person stepped out in the street. But
Can we go back
that's,
to, can we go back to Justice Markman's question for a second? Because I think that he hit on what gets hard, because you would probably agree with me that if Mr. Johnson filed this case on behalf of a 23-year-old college senior who the record reflected regularly stood up to his coach, told his coach when he was, telling him to do things that didn't make sense, we probably wouldn't be here. And the same is true if Mr. Johnson's client was a kindergartner and it was kindergarten girls on the run running club running in the dark at 6 a.m., you probably wouldn't, you would have made sure we weren't here. So those cases go away. The 13-year-old is a little bit harder, right? And so are there questions a court could ask to sort out whether the 13-year-old is more like the kindergartner or more like the college senior? For example, would it matter what the nature of the authority the defendant has over the child, whether the child could appreciate the risk, and whether the child reasonably felt compelled to act? Are there things a court could, are there ways a court could help so that it's not just everyone's gut feeling about whether the plaintiff, should be held responsible for making a decision that cuts off liability to the government actor?
in some ways, you're kind of referring to or taking us back to the old rules of sevens, of presumed and presumed yes, presumed no, and later. I would argue that here, where you've got a ninth grader, that the ninth grader legally in this situation isn't
But
different.
you're arguing the factual question here. I was just trying to ask, is there a way we could think about this question in the hard cases?
Well,
I know what your position is on this case. I know where you want this to
She's
go.
asking a doctrinal question.
Yeah.
Is there a school child, however defined, exception to Robinson?
No, not exception. Is there a way we could think about it? You know what I mean? I don't know about exception. You don't want to do that.
I don't understand then the concept of how we factor in unless we're talking about a person with no competence, as in Justice Bernstein's hypothetical, where the injured party is entirely dependent on direction of another, or we're talking about an infant who has no capacity. But if we're talking about someone who is is subject to the statutes pointed out by the plaintiff in his brief, the ones that require you to obey traffic signals and look both ways, if a person is obligated under those statutes to follow those rules, I'm not sure how we get an exception.
I think, if I understood Justice Markman's statement, it's a legally significant. Is there a legally significant proximate cause? And that's what I think is the defining thing here in this case, is that you have a rational, fully capable individual, ninth grader, who it is legally significant for him to take the act that he took. And so when you analyze the facts and you see the legal significance of the physical action that he took at
Counsel,
that
what's
time,
more significant?
that's the intervening
What's more
proximate
significant,
cause.
autonomy or foreseeability?
What, did you say autonomy or foreseeability?
Autonomy or foreseeability?
Autonomy?
Versus foreseeability. The autonomous nature of the student versus the foreseeability of the injury.
I don't know that I can answer which is more significant. In each of the cases that the court has addressed before, the fact that there could be an injury was foreseeable. And the cause of the injury, although
How do we balance the issue of autonomy? That's the question. How do we balance the issue of autonomy, the autonomous nature of the case that is being presented here?
Well, I don't think that there isn't any suggestion or any evidence that the student didn't have full autonomy. I mean, it is the actual physical act of running. backing up to getting up that morning, backing up to going to school, backing up to participating in cross-country, backing up to whether you feel a cramp in the back of your leg or you're feeling nauseous, takes us to the Tarlia
But you
case.
haven't answered
You
the
had-
distinction- But you haven't answered the distinction.
student
What
al-
do you do when you get an order? That's what I'm trying to struggle with. In this situation, there was an order given or the question of an order given. How do we address as a standard, not necessarily in this case, when you have an order that is given? How do we get into that? How do we address that?
Well, my answer would be, and particularly in this setting to the students that are participating here, simply because and again, I don't mean to trivialize, but, you know, if someone told you to jump off a bridge, would you jump off a bridge? And the answer is no.
But
And
if the
if
teacher-
you are,
wait,
and there's no
If
dispute.
it's a teacher, you don't think there's any distinction between the fact that it's a teacher that is giving this instruction to a subordinate student?
I don't think in these facts, there's such legal significance. A hypothetical that I would say might be
We're
different
not going
would
to
be
engage in a
if,
hypothetical.
I'm sorry.
Because we are concluding. Thank you very
oh,
much.
thank you, Justice.
Thank you, the audience. If you will remain here, we will have the counsel for the parties entertain your questions, and we thank you for your courtesy. No, he did not. He was well beyond his time. Thank you very much.